Hello, and welcome to All Things Chemical, a podcast produced by Bergeson and Campbell, a Washington, D.C. law firm focusing on chemical law, business, and litigation matters. I'm Lynn Bergeson. On June 25th, 2025, Bergeson and Campbell, along with the Environmental Law Institute and the George Washington University Milken Institute of Public Health, sponsored an all-day virtual conference titled TSCA Reform 9 Years Later. The conference was hugely successful, and almost 1,000 people registered for it. The quality of the discussion, the caliber of the participants, and the timeliness of the content motivated us to repurpose the substantive sessions to enable our podcast audience to listen to the sessions in this venue. Our topic in this podcast is the EPA's new chemicals review process under Lautenberg. As many of our listeners know, the TSCA New Chemicals Program was significantly revised in the 2016 TSCA amendments, and what the law requires has been vigorously debated and remains unclear to this day, 9 years later. This spirited panel discussion addresses OPPT's new approaches to assess chemical risks, to accelerate the process, Section 5E orders, recent trends with EPA's review of new chemical substances, and much, much more. Now, here's the panel discussion on the TSCA New Chemicals review process from TSCA Reform 9 years later.
We're about to get started with panel 3, which is New Chemical Review. And joining us, we have Greg Schweer as the moderator, who's a principal at Environmental Consulting, LLC. Greg retired in 2020 after nearly 20 years at EPA, where he primarily served as EPA New Chemicals Management Branch Chief. In this position, he managed the risk management portion of the NCP mandated by Section 5 of TSCA and led NCP through significant policy and implementation changes resulting from enactment of the Lautenberg Act. So, Greg, I'll hand things over to you if you want to get started with introductions.
Thanks very much, Madison. Well, good morning, everyone. I'm honored to be the moderator for this distinguished panel of experts on the New Chemicals Program. Although we have no EPA representatives on the panel this year, I think our panel is unique in that everybody on this panel at one time in their career worked for EPA. In fact, 3 of the panel members worked in the New Chemicals Program. So this group of people is very familiar with the New Chemicals Program. Actually boots on the ground kind of experience. I'd like to briefly introduce the panel members to you. First, we have Dr. Kyla Bennett. She's a PhD ecologist. She's the Director of Science Policy for Public Employees for Environmental Responsibility, PEER. She previously worked at EPA Region 1 for 10 years as a wetlands permit reviewer and as the region's wetland enforcement coordinator. Her familiarity with science, the law, and inner workings of state and federal government agencies enable her to assist public environmental employees. She also has a law degree from Lewis and Clark Law School in Portland, Oregon. Next, we have Larry Killeen. Larry is a partner with Arnold Porter K. Schuler. He represents clients on administrative, regulatory, and enforcement matters involving federal agencies such as EPA, Department of Agriculture, Food and Drug Administration, and the Consumer Product Safety Commission. Prior to joining Arnold and Porter, Larry held leadership positions at EPA, including in the TSCA New Chemicals Program and in the Pesticide Registration Program. Next, we've got Dr. Maria Doa. Maria is a PhD chemist. She's currently the Senior Director of Chemicals Policy at the Environmental Defense Fund. Her primary focus is on reducing exposures to toxic chemicals through health protective implementation of the nation's chemical safety laws. Previously, Maria held a number of leadership roles at EPA, including leading activities for the assessment and management of a wide range of industrial, commercial, and consumer chemicals, including TSCA New Chemicals. And finally, we have Dr. Rich Engler. Now, I did it with this alphabetically, and it's weird that E is the last letter of this group of people. Rich is also a PhD chemist. He's currently Director of Chemistry with Bergeson and Campbell. Previously, Rich worked for 17 years at EPA, including EPA's Office of Pollution Prevention and Toxics, New Chemicals Program. He assists clients as they develop and commercialize novel chemistries. Rich writes and speaks frequently about the opportunities for industry to use TSCA to their competitive advantages and the challenges that newer chemistries and technologies sometimes present. This panel today is going to try to address and provide updates on the PMN completeness, PMN supplemental submissions and rework, the approach to significant new use rules, confidential business information issues, and the burning topic of adequacy of resources we've heard about numerous times today. Our format is similar to that used by the previous panels. We have sets of questions during dealing with a variety of these issues. And for each set of questions, we have designated two speakers to start the discussion, and then anybody can join in. So let's get started. The first series of questions is as follows, and Rich Engler will lead the discussion and then followed by Maria Doa and anyone else. In December of 2024, EPA finalized amendments to the TSCA new chemical regulations. One of the main purposes of these amendments was to improve the efficiency and consistency of EPA new chemical reviews and to reduce the backlog of PMNs awaiting final determinations. Has EPA improved the efficiency and consistency of its reviews? And have submitters improved the completeness of their submissions? Have you observed any other improvements, impediments in the new chemical review process resulting from the recent amendments? If so, in what way? Take it away, Rich.
So I think we can all agree that rework is in nobody's best interest. I mean, it's not a good use of EPA resources. It delays submitters extensively, and we're just not using the process efficiently. If anything has to be reworked. So let me just say up front that we very much try to avoid rework. But when we're assisting clients in preparing PMNs and other new chemical submissions, even prior to this rule, we did our best to provide EPA with a very complete picture of the hazards based on test data, based on analogs, based on models, as well as the exposures, what was known by the submitter and what they could glean from their customers. So, and I recognize not every submission is complete as maybe one that we're assisting clients with, and that's that is an issue. So this rule, which the primary purpose, the primary effect of the rule, is that now rather than leaving some parts of the PMN before the rule, some parts of the PMN form were required, that the submission was incomplete if there was not information put in those fields. With the rule, and other fields were optional. If you knew it, you could include it, but you were not required to include it. And sometimes that information was blank, and it certainly was back in the old days prior to Lautenberg, and it has been the case recently. And so now with the rule, you can no longer leave those fields blank. Now you either have to provide information or you have to assert that information is not known or reasonably ascertainable. And unfortunately, the CDX system, and there's a lot of things that need to change in the CDX system. It's not set up to validate those blanks right now. So the way the system's working right now is if it's not known or reasonably ascertainable, you have to explain in an attachment that information is not known or reasonably ascertainable. And it's certainly in a submitter's interest to provide whatever is known or reasonably ascertainable. Whether that's made a difference, I don't know yet. I think it's too soon to tell. We haven't seen enough cases be submitted and reviewed after the rule took effect to know if there's been a substantial change in rework. In our experience, rework, I mean, occasionally there'd be rework because EPA needed information that we didn't provide in the initial submission. But in most of the cases where we dealt with rework, it was because we disagreed with EPA on either its exposure assessment or its hazard assessment. And in some cases, we disagreed with EPA because EPA simply missed information that was provided in the PMN. There were cases where information was provided, EPA did not see it, made some worst case assumption, and found unreasonable risk. And we pointed out that, no, that information was right here in this attachment on page, whatever it was. And then EPA had to go back and rework that. So there are lots of reasons for rework. And And this rule will help some of them, but it's certainly not going to eliminate disagreements with EPA or errors on EPA's part, or in a recent case we had where we provided analog information and EPA had data on an analog that was CBI. We were not aware of that CBI analog. And so that was a case where, we thought we had a good fact set, but EPA had information that we had no way of being privy to, and that led us to some potential rework discussions. So I think the answer is it's incomplete, but this isn't some magic wand that's going to prevent rework.
Thanks, Rich. What do you think, Maria? Have any comments?
Well, I think the amendments will help with the issue of rework. And because a lot of the rework, as EPA has documented, is due to EPA receiving additional information mid-review when the submitter, as Rich said, pushes back on EPA's risk assessment or any of the restrictions EPA identifies. And often what happens is the submitter will say, oh no, I have better information or more detailed information. And when that comes in mid-review, EPA needs to spend the time to redo the assessment to address that new information. So hopefully these amendments, given their greater specificity, will help with getting some of this information up front. And I would take a little bit of issue of saying EPA is asking for more information. What happens is EPA uses its standard process and identifies risks. And that's often what triggers the submission of the additional information, because the submitter is trying to say, wait a second, I really don't have risks, or the restrictions that you want to put on my chemical are too much, and I have better information that shows it's not so much of a problem. And the thing I would point out also about this is that when EPA is doing that rework, it takes them away from working on other cases. So hopefully the amendments will help on that. And then just finally, in terms of taking EPA resources away from doing these assessments, I wanted to follow up on something that Rich said about where the submitter disagrees with EPA's assessment. And I just want to remind everyone that EPA is supposed to be the independent reviewer of these new chemical submissions. And it's not like a co-decision from EPA and the submitter. Thanks, Greg.
Kyla, Larry, do you have anything you'd like to add?
Just second what Maria said there.
Yeah, I'll add two things. One is I question whether the amendments will change this, episodic need to review and do additional reviews or gain additional information throughout the review process. I think, the way I read the amendments is, that we have the capacity, if you will, to send you back to square one, do not pass go, do not collect 200. And I think that's actually going to create work, not lessen work, just a bias on my part. I think another facet that we haven't discussed in this brief conversation has been the obligation that the amendments from 2016 impose on the agency to consider other reasonably foreseen conditions of use. And I think that has necessitated agency reviewers to look perhaps differently at the risk assessment portion of PMN reviews than they have previously. And so I think that's also when some collateral points of view with regard to where exposures might occur, sometimes not even contemplated by the PMN submitter. And then, potentially there's responsive submissions made based on those suppositions or predictions. So I think it may be a little bit more nuanced than we all necessarily would assume to be the case. So hopefully there will be improvements. I think the incentives are certainly there for people to submit as complete a submission as possible. So we'll see. And I could go on and on about some areas where I think that could be encouraged, but why don't we move on, Greg, and we'll see if it comes back around on that.
I think it very well might come back around, but let's move to the next set of questions. Okay, are there improvements in areas? Well, it's actually, we're moving on. It'll come back right here, I think. Are there improvements in areas related to timing, consistency of assessments? What more can EPA do to speed up the review process without sacrificing quality? What more can submitters do to improve the completeness of their submissions to avoid rework? When EPA determines that industry submitted studies or other data are not applicable, anecdotal, not representative, or not of sufficient quality, what level of justification should EPA provide to make that decision? How can the determination to include or not include information be communicated to other stakeholders who are affected by EPA's new chemical decisions? All right, so it's a nice lead off right to you, Larry.
Okay, well, picking up then the thread, I think where we left off, I think it would be helpful, but I don't think resources necessarily permit that the process by which submitters are preparing and making their submissions could be more interactive. And again, I don't think human resources permit that. But I think as people complete the notice, if the opportunities for pre-notice consultations of a more substantive nature existed, and again, I think that would require staffing changes, but I think earlier engagement, particularly on chemicals that may be of concern, would enable the submitter to fashion an improved submission if the participants in such a meeting might include exposure assessors and toxicity evaluators, risk assessors, so that there could be more of a dialogue. I think the volume of submissions and the quantity of experienced staff are so limited that that's unlikely to occur. But I think that would be a druther if I were designing a program. And then similarly, I think if there were an interval early in the process, I'm going to use old language that is no longer relevant, but sort of a post focus type discussion that could occur with the submitter to alert them to areas of concern. I think, again, it might involve a more meaningful exchange and make the reviews more both substantively improved and maybe even lessen the need for rework. Again, I think that's a staffing issue and also a level of sophistication issue where, as an increasing effort is made to bring in resources to the program, to the extent those resources that come in, maybe people who are new or not know the vocabulary or not understand the rhythms of the program. I think that's going to be quite a challenge to achieve. But I do think there's incentives on sort of the agency side and submitters side to have that kind of interactive process if everybody had, all the people and money in the world to run the program.
Yeah, I mean, just as an anecdotal thing, I think we had a pre-notice. When I was there, we had pre-notice program. I think when you were there, we did as well. But I think it is becoming probably more critical that a more robust program be developed now, if resources allow. That's just my thought. Kyla, would you like to weigh in on this one?
Yeah, thank you. Absolutely. I think the best way to improve consistency and efficiency, speed, is to increase transparency. And having more eyes on the data will improve that consistency. And while I realize we're talking about CBI later in this panel, I think it's critical to mention here that EPA and the submitters' overzealous protection of so-called secret data is harming both public health and the environment, and it's harming these consistent, transparent, and good science decisions. So EPA needs to ask, how much can we disclose, rather than asking, how little can we get away with disclosing? Health and safety studies cannot be CBI, and yet Pure right now is in court because EPA wanted to release some CBI data and the company is suing to have it not be released. It's a constant battle. And Rich made an excellent point on the first question. He made my point for me. You have to keep in mind that EPA is the only entity involved in this whole process that has the full view. They have CBI, and only they have CBI from other submitters on the same or very similar chemicals. If we had enough employees, good training, well-articulated standard operating procedures, and the justification of which studies EPA decides are worthy or not worthy would not be a heavy lift. We need something more workable, faster, and more transparent than systematic review. So that being said, I think what EPA should do is look at the 5 factors in TSCA 26H and make some type of rubric, if you will. Those are 26H has mandatory scientific standards. Why don't we just use those? Those 5 factors are: the information has to be reasonable and consistent with intended use. The information has to be relevant to EPA in making its decision. There has to be clarity and completeness of the data, the assumptions, the methods, the QA and QC, and the analyses. There has to be variability and uncertainty evaluated and characterized correctly. And finally, there has to be independent verification or peer review of the information. If EPA develops a rubric and has scientists rank the studies with those 5 factors, ranking them on a scale of 1 to 3 or 1 to 5, it would be more transparent for both the submitter, for the public, and for other scientists in EPA. And I think that would go a long way to making this process go more smoothly. And the last thing I want to say is that if EPA truly wants to speed up this review process, it needs to stop overruling its own scientists who are trying to protect human health and the environment. We have to keep in mind that the goal of TSCA is not to get more chemicals on the market as much as industry thinks it is. It is to protect human health and the environment from unreasonable risks associated with these chemicals. Full stop. And I think that EPA has lost the forest through the trees here.
Thanks, Kyla. Would you like to add anything, Rich?
Yeah. So, you mentioned pre-notice, and pre-notice has become less effective than it had been in the past. And I understand that the reviewers are very busy, and it's very challenging for reviewers who need to focus on the obligations of reviewing cases to pull time away to do in-depth reviews of information prior to the submission. And we've recognized that, and don't push back. The one thing I push back on is when EPA managers say, "Oh, come in for pre-notice discussion, and we'll resolve all these issues prior to submission." That's not how it works, because the staff just do not have the bandwidth to do it. One of the things that we've been doing with clients is using low volume exemptions effectively as pre-notice consultation, where we'll put the fact set together in an LVE with a tonnage limit, and then get EPA's view of, say, the hazard assessment and the hazard data that's associated with the PMN, so that we get that thorough review of the information. And then if EPA finds that there's not an unreasonable risk and the EPA can grant the LVE, then the company can proceed to commercialize under that 10-ton limit while they prepare and submit a PMN later. But that's the only way to really get a thorough review by EPA for the information that you're submitting. The frustration we have sometimes is we provide very thorough information and we get a perfunctory dismissal by an assessor. And I'm not saying that EPA can't disagree. It's just like, give us more than a sentence saying that's not acceptable. And that goes to transparency. It also goes to rigorous science, right? If you're going to disagree, fine, explain why EPA science is better than the science that we suggested.
Okay, that was a good discussion. Let's move on to the next.
Could I add something, Greg?
Sure.
I wanted to second what Kyla said about the transparency, and certainly from being at EPA and not being at EPA now, it's just amazing, just the health related data that just is redacted, number one. And then the second thing about this discussion is just a reminder that EPA is making a determination on a safety determination, and that
It's not good. I think we lost her.
Yeah.
Can you still hear us, Maria? Is there a way you can send something in the chat? She was having problems earlier today. Could be that she's so far away.
Oh.
Well, I'll tell you what.
Oh,
Oh, you're still there. Okay. Good.
sorry, I came back from Uruguay. The third thing I would note is that EPA does have the complete picture because they have this database with all those past submissions. And so when they are looking, and if they push back on data that the submitter has provided, they're doing it in the context of that broader information and on the analogs. And then, so that gives them, you know, much more depth. And often what they get is anecdotal data from a submitter. And then this is so important, going back to a point that Larry made, is that this information is used for reasonably foreseen uses. This is really key for that. And so those EPA's decisions on that are, I think, more informed than they often get credit for. Thanks. I'm sorry about the technical.
Okay. All right. Let's move on to the next question. Changing gears a little, we're going to talk about consent orders and SNRs, significant new use rules. Some have contended that EPA is over-regulating new chemicals by issuing so many more TSCA Section 5 consent orders and SNRs than before the Lautenberg amendments. They further contend that this impedes innovation and that the presence of a SNR makes it more difficult to market these new chemicals. At the same time, EPA has been very slow to issue new chemical SNRs that mirror the consent order, which some new chemical submitters believe put them at risk of someone else making the new chemical without the restrictions they are under. OPPT published 9 proposed batch SNRs in 2024 and also finalized one of those proposed rules in 2024. Under the current administration, only one batch SNR rule has been proposed to date, and none of the outstanding proposed rules have been finalized. Why do you think there are many more consent orders and SNRs issued by EPA since passage of the Lautenberg amendments? And do you agree that the number of consent orders and SNRs impede innovation? Also, do we know the reason or reasons for this apparent slowdown in SNR rulemaking? Who do we have going on first? Okay, Maria, that's you. It's a lead off.
Yes, and I think the number of consent orders and SNRs are tied to the Lautenberg amendments, certainly, because the finding EPA needs to make, they need to make an affirmative finding on the safety of a chemical. But at the same time, I think it's worth noting that EPA routinely approves for commercialization highly toxic chemicals, albeit typically with restrictions. Indeed, many new chemicals raise significant concerns for toxicity, such as the metal-based chemicals used for electric vehicle batteries, the persistent and bioaccumulative toxic chemicals, including new PFAS used to make microchips, and the new complex mixtures derived from plastic waste. It's also worth noting that while there are benefits in bio-based chemicals, the fact is that being bio-based does not necessarily mitigate the toxicity, and these all get approved. I think the other issue in thinking of the chemicals that you see in the new chemicals program is that there's little incentive for industry to design truly safer chemicals given the risk framework of TSCA. Given that risk is a combination of hazard and exposure, And the regulation of new chemicals often is primarily through limiting the exposure to the new chemicals so that you can control the unreasonable risk. And so you'll get worker protections, limitations on releases to water, limitations on consumer uses, concentration limitations. And that's why you'll see the consent orders and you will see the SNRs. And I think the issue of consent orders and SNRs gets to the point, like the regulated communities over-regulating. EPA, again, I've said it twice, I'll say it a third time, is supposed to be the independent assessor. And its intent, as Kyla said, is not just to approve new chemicals, it's to look at these chemicals and determine that whether they may present an unreasonable risk or not, and if they may present an unreasonable risk, to put restrictions on them so that they don't present the unreasonable risk to workers, communities, consumers. And as I noted at the beginning, they do approve most new chemicals. Thanks, Greg.
Okay. All right, Rich, I'll pass it off to you now.
Yeah, so I think the question, the fundamental disagreement here is whether if a new chemical substance has any hazard, if a restriction, whether it's an order or a SNR, it necessarily follows. So as EPA's largely done, I think there are a handful, maybe fewer than three cases, or maybe three cases where EPA has identified a hazard other than low hazard for health and the environment, where EPA has not issued some restriction. So it's a departure for me to look at what is clearly a risk-based statute to say, look, if there's a hazard, there needs to be a restriction because there might be at some point in the future some release or exposure that is an unreasonable risk. And the statute does, right? The threshold for no regulation is not likely to present unreasonable risk under the reasonably foreseen conditions of use, of course, including potentially exposed and susceptible subpopulations. So there's a question of what is reasonably foreseen and how likely is not likely. What we find the EPA doing, and I've actually gotten folks from the new chemicals program to explicitly tell me that what they're doing is they just look at what's intended, what the submitter intends, what's in the submission, or if the submitter amends the submission, the amended submission, and if what's intended is not an unreasonable risk, that can go forward. But then everything else has to be prohibited somehow until EPA can look at that. And so it really is no consideration of what's reasonably foreseen or how likely these things are to happen. And that's where I think there's a departure from the statutory language. The donut hole, as I like to call it, between when the order is issued and when the SNR is final, is an enormous problem. It's an enormous commercial problem for submitters, and it's basically this donut hole of protection. They're right. Only the order signatory is bound by the consent order. So if somebody else can come in and find the substance listed on the inventory after the submitter has commenced, then that second company can immediately begin manufacture, import, process, sell, use, without the protective terms of the order until that SNR is final. And when you're talking about basically 2 years from order on average, 2 years from order to final SNR, that's an enormous gap in protection. And it's a commercial disadvantage for submitters, and it's a lack of protection to workers in the environment and the general public. So we need to pull the SNRs in sooner. I thought the non-order SNRs during the first Trump administration was a permissible and creative read of the statute. That the presence of the SNR limited what was reasonably foreseen, and so EPA could proceed to a not likely determination with the restriction that avoided the EPA's, the effort for EPA and the submitter to enter into an order, assuming no testing was necessary. They didn't need the effort of the order, and the SNR protections applied across the supply chain immediately. But I mean, fundamentally, I disagree that 92% of PMNs need to be restricted in one way or another. I just do not think that meets what was intended by Congress.
Well, I
Hello,
think
Larry. Oh, go ahead, Maria.
Well, I think part of that, I wouldn't just say that was what was intended by Congress or not. It is a risk-based statute, but I think if safer chemicals were designed and came through the new chemicals process, then they wouldn't regulate because EPA is not regulating on EPA is not regulating on hazard. They are
Yes, they are.
they are regulating on risk, and they approve on some highly toxic chemicals with restrictions that could be stronger. So I think we just disagree on that point.
We're trying to wrap up negotiations with EPA on a carefully designed, very green laundry ingredient, and we have gone back and forth with EPA over what circumstance there would be an exceedance of EPA's surface water concentration concern, and EPA has been unable to identify when there would be an exceedance. Every scenario that EPA provided, we've been able to show that that would not be an exceedance, and we still cannot come to agreement that there is a reasonably foreseen condition of use that would exceed. And EPA is standing firm on, you know what, we're done. Here's your order terms, and this is that, and that's the final offer.
Well, I guess it gets to the point where you and EPA disagree over it, and EPA should be the independent assessor of this and decider.
So, okay, so EPA is always right.
It is their job.
I understand it's their job, but if we disagree, I mean, in the end, there is a statutory interpretation, there is a legal interpretation of what's in the statute, and there has not yet been a case on what is not likely to present unreasonable risk under the reasonably foreseen conditions of use. New chemical submitters are very reluctant to challenge EPA on that legal matter, mostly because they don't want to invest the money in a product that's not yet commercial. And what they're doing is, to the point about innovation, they're just abandoning the U.S. market. They can't get to market, or they can't get to market with terms that the supply chain can manage, and so they're selling into cosmetic ingredients because they can meet the statutory standard for cosmetics, or many of these things have been registered in Europe, even up at Annex 10, without any challenge. Canada, China, Korea, and it's only under TSCA that these things are being restricted in these ways that just, to me, even the very greenest ingredients that we've seen are getting restrictions. And I mean, as a green chemistry proponent, it breaks my heart to see carefully designed green chemicals being so commercially disadvantaged when they're so vastly better than things that are already on the market. So they can't meet that low hazard threshold, EPA's low hazard threshold, and so they're just stuck.
So the question from me to you, Rich. So you think that SNRs really are such a black mark on a chemical that, and if they are, what could the agency do if they feel that they must issue SNRs to educate the public on why it's not such a bad thing?
Well, it's not. I mean, part of it. I mean, maybe we can change people's attitude about whether it's a black mark or not. But what we can't change is the enforcement risk when you have a SNR substance in your supply chain, right? If you have a SNR substance in your supply chain, not only do you have to comply with the SNR, but you have to have records that document compliance with the SNR. Absence of a record, if you don't have that piece of paper that shows we complied with this, with these provisions throughout, the 5-year time frame of the inspection period, that's a violation. And Section 5 violations start at $45,000 per substance per day. So every day that you've manufactured or imported, processed, used a substance that you don't have a record of documentation is 45 grand. And over 5 years, that adds up. SNRs and consent orders also trigger 12B obligations. So if you export 200 grams of a snr substance to a lab in Europe because you're doing testing, and you fail to tell EPA you exported that 200 grams of substance to that lab, that's $12,000 in fines. So there are enforcement risks, and they are serious enforcement risks. And companies, some companies, I think, legitimately go, you know what, you've got this great new chemical, that's wonderful. I don't want the risk. I'm going to stick with the old stuff, even though this new stuff is better.
Can I just add a practical possible solution to this? I mean, the not all snr chemicals are created equal, and in fact, pre-Lautenberg, most of the snrs were on pretty dangerous chemicals, right? So, but on the inventory itself, the snr chemicals have that S flag with no other information, and sometimes, especially the post-Lautenberg ones, they're not that dangerous. So, what about if EPA added some more information on the inventory regarding those snr chemicals? First of all, whether they were pre-Lautenberg or post, but also, change some flags, add whether it's consumer use versus industrial use, and is it because there's no releases allowed to water? Is it going into a consumer product? Give the public more information so there's not that automatic knee-jerk reaction that a snr is dangerous and a snr chemical is dangerous and it shouldn't be used.
Well, I mean, that information is available. It's not on the inventory, but you can connect based on a CAS number or a PMN number. You can connect on ChemView or in the Federal Register. You can connect. It is critically important that people that not review a summary of the snr. They need to look at the actual snr language itself to make sure that they understand what those snr conditions are and that they're not undertaking a significant new use without issuing a SNUN. I have seen in ChemView incorrect snr conditions in the ChemView summary. So you really have to look at the actual snr itself and not a summary, whether it's on the inventory or in ChemView. But again, the enforcement risk is regardless of how toxic or non-toxic the substance, hazardous or non-hazardous the substance is. The enforcement risk is simply derivative of the existence of the snr.
So I think there are a couple points. One is, just remember a chemical that may not be problematic in an industrial or commercial use can be very risky for a consumer use. So I think that is why there are a number of snrs. The other thing is, if you have a bio-based chemical that maybe is toxic or has some corrosion, but it's better than something that's already on the market, approving this without restrictions does not take that original one off the market. And if this were the case, we still wouldn't be trying to regulate things like chlorinated solvents like TCE and methylene chloride, and they haven't come off the market. So it's not, you just don't pull that off the market. So I think that is important to consider.
Yeah, and I think at the risk of barging in, I don't want the point, which is sort of in my view, one of the 800-pound, whatever we are, gorillas, elephants at this point in the room, and that is that the program historically, I think, has been challenged by the notion of comparative risk or substitution. I think, Maria, your point's an excellent one, which is often it's not a one-for-one substitution, or there's not a taking off of the market, if you will, of a substance for which there may be I'll just call it a safer substitute for lack of a better term. And I don't think, and in fact, I think there's an argument that the 2016 amendments may have made this situation worse, not better. Because if you look at the terms of the statute, there isn't, in my humble read, a vehicle to allow EPA to exercise some discretion with regard to issues such as comparative risk or favorable substitutions. I think that is an area that will unfortunately probably not be critically examined, and maybe it will at a later panel on the legislative changes issue, but I've never seen that even floated as a potential amendment idea among the, drafts and things that are kicking around Washington. And I think as a policy matter, that's where smart people ought to be thinking, because I think the agency's business and the country's concern with regard to chemical risks could be better served if the agency was empowered to a greater extent in that regard, or felt empowered. And also, as a commercial matter, I think Maria's point is an excellent one. If a submitter of a substance is going to represent that they have a better substitute, they should also be able to articulate how it will substitute and whether they're in control necessarily of the substitution. And again, hypothetically, and not knowing any of the facts in the situation we've been entertaining, is the maker of a detergent able to say, I make the other one that has the chemical that's of greater concern, and I will be substituting my product one for one as I'm allowed to increase, distribution, or as it takes hold in the market. I think if the agency could somehow come up with a way, or the regulated community could come up with a way that we could make that happen, we would all benefit greatly. Because if the greater mission is really risk reduction, let's really challenge ourselves to figure out a way to get there instead of, just pointing fingers at, who's slowing up things.
Yeah, for the audience, just so you understand, SNRs aren't some strange little thing that's just affects a few chemicals. I mean, the numbers I was looking at least around the time Lautenberg was issued, was the EPA had issued SNRs for over 2,300 chemicals years ago. So we're dealing with thousands of chemicals that are regulated with SNRs. It's a big deal. Okay, well, let's move on. We're running out of time a little bit, so let's move on to the next question. This is about adequacy of resources. The other panels have talked about this as well. The board of directors of the EPA Alumni Association wrote a letter to EPA Administrator Lee Zeldin on May 19th, warning that, quote, without full staffing, full funding, and a full complement of regulations, end quote, EPA will not be able to adequately protect human health and the environment. Concurrently, it has been reported that staff from some offices in EPA may be able to obtain positions in OCSPP, thus potentially mitigating some of the staffing losses that are occurring. With regards specifically to the TSCA New Chemicals program, do you share the concerns of the EPA Alumni Association, and what can be done to address these problems? And we start off with Kyla.
Yep.
Yes.
Thank you, Greg. And I share those concerns 100%. And I think for EPA, the first step would be to admit that they have a serious problem. EPA has made attempts, obviously. Dr. Friedhoff's pleas on the Hill for years asking for more money. This administration's $17 million for technical improvements, but they've never fully grappled with or publicly shared how serious and widespread the resource problems are. And so it starts even before submission, right? They have inadequate and outdated guidance. Some of the guidance is from the 1980s. They have continual technical glitches with CDX, broken IT infrastructure. Everything is under-resourced. The contractors that review new submissions and prepare those first drafts, the EPA staff that review those drafts, program managers that perform the risk evaluations, even the OGC attorneys who support the rulemaking and give advice to the program, consent order process, the SNR process, all of it. It all needs more resources. And because every step is under-resourced all the way to the very end, where the publication and transparency part comes in, ChemView, the docket, the Federal Register notice. Sometimes that can even come too late for anyone but the submitter to provide input or feedback. So EPA keeps pretending that small process improvements, streamlining, and better training will fix new chemicals, but it won't. And I think more importantly, and I have to say this, and I apologize in advance, but EPA thought that by transferring out my whistleblower clients, the ones that the Inspector General found were illegally retaliated against by the agency, that would unstick the gears and speed things up. And it didn't. It did not. They removed a number of talented, well-trained, and intelligent staff members and replaced them with new hires. And as far as the movement of ORD people into OCSPP, what we're hearing is that the people from ORD who are getting RIFT, who have experience in OCSPP, are not even getting interviews. And that this process of bringing some of those people over from ORD to OCSPP is more of a let's get yes men and women than scientists with the very expertise that they need, those people that can hit the ground running. So if New Chemicals really wants to convince me and the rest of the people here that they're going to fix things, even incremental improvements, they need to be honest about what the resource needs are every step of the process. They need to look at the GAO and IG reports that have already been written on this and try to implement the changes that they suggest. And again, I would be remiss if I didn't reiterate that the goal of TSCA is not to get as many chemicals on the market as possible. It is to protect human health and the environment from unreasonable risks associated with these chemicals. And there are ways to do it, but they have to prove why they need more resources at each and every step. And also, getting rid of ORD is absolutely nonsensical. They support OCSPP, and it's just stupid.
Okay, Larry, your turn.
I have a concern that I'll articulate slightly differently, and that is that one of the phenomena I think that is true within the New Chemicals program, I'll just say, is that it is difficult to have people within the program who have both experience and knowledge about not only the process but also the science, also not only the toxicity but the exposure side, to just sort of hire them new or move them in from another program office and have them have that level of expertise. One phenomena that occurs from, I'll just say, with some frequency, which is somewhat frustrating, is that a PMN submitter will get a call from a staff person who's the notice manager who will say, we're going to regulate the chemical, or we need a suspension because we're still doing this, and there sometimes a lack of, I'll just describe it of ownership of the PMN and of the process and of the overall risk assessment and management facet. I don't know how you get that with somebody right off the proverbial turnip truck. I think you need somebody who has some gravitas that only comes from experience, and those people are going to be fewer and farther between as there's incentives to leave the agency either for economic reasons or other reasons that might cause that level of exodus. And I think that is an area of what should be shared concern by both PMN submitters as well as people in leadership positions at the agency. Because when you get a phone call from somebody who essentially is just, not my table kind of discussion that you get engaged in, and they can't really discuss with you the basis for certain issues or concerns, that is disconcerting. And so people who take the time to submit PMNs and then get a response that's thin get frustrated by that. And I think all parties would benefit greatly by having people of some stature and experience that only comes from seasoning. And I hate to sound like a geezer, but I think that's true. And I think you got to get there by getting the right people in the room and then training them up and not encouraging them to let the door hit them on the way out. So I think you got to invest in staff, train them, embrace them, and encourage them to feel responsibility about the program.
I agree, Larry, and I think it's something we've been arguing for quite some time now, is the resurrection of the Sustainable Futures program. Even if there's not some review time benefit being able to update all the policies and procedures, bring them into the now under the current statutory construction, using whatever EPA's current interpretations are, make sure that all of that systemization has been done, and embed that in the training program that is Sustainable Futures or whatever you're going to call it going forward. I mean, the reason it existed in the past was to train submitters to understand better EPA's approach to new chemicals, and then they could design new chemicals to get to design a chemical to have an easier path to market. So understand where EPA's concerns are, how EPA would assess, and so that you could, as a manufacturer, as an innovator, you could try to aim for that threshold. Now I think it's even more valuable, especially since everything with the hazards being regulated, it's more valuable not to design to that low hazard threshold, because it's very, very hard to reach. Even the safer chemical ingredient list doesn't meet EPA's low hazard threshold, most of the things on there. But it would be useful, not just for submitters, I think it would be very useful for training new folks so they understand how the entire process works, not just their little slice of it. Larry, to your point, you need to understand how the decisions as an individual, how the decisions that you're making fit into the bigger picture. And I think it would also help with transparency for that folks outside of EPA and that aren't the submitter that want better understanding of how EPA is reviewing new chemicals and what that output looks like when they're getting reports out of the docket or whatever the output is that EPA is producing. You can look at that and understand what assumptions EPA made, when did EPA use its models, when did EPA use submitter information, and how that all came together in a risk picture. So, and I also want to point out, during the first Trump administration, the president proposed draconian cuts, and Congress either entirely or nearly completely restored those cuts in the final budget. So we've continued to see these presidential budgets with really horrible cuts, and I agree that would be a major issue. But so far, OCSPP, especially the regulatory work within OCSPP, has been protected. I was delighted to hear that there were the February DOGE cuts were that the regulatory programs within OPPT were protected from those DOGE cuts. There was unfortunately an enormous wave of early retirements just a couple of weeks ago. Where a lot of folks that Greg and Maria and you and I worked with, availed themselves of that opportunity. That's going to be a major blow, and we are going to need to get new people in there. Larry, to your point, this is a very challenging position to learn outside of the new chemicals program. And that's why I personally think that standing a Sustainable Futures program back up is an opportunity to get people trained.
Okay. All right. We have about 5 minutes left. So why don't we move on to the question about CBI issues? Okay. I think we lost Maria. She did say that she may be having to leave.
She's dropping a noon, yeah.
All right. Last year, this question was asked of the panel, the new chemicals panel, and I think it's still a relevant question today. Members of this panel and others have said that submitters at times overclaim information about their chemicals that they submitted for EPA review as CBI, which results in that information being unavailable to the public. Do you think that companies have any incentive under the current system and EPA practices to stop doing this? If not, what ideas do you have to stem overclaiming? For example, what rules or practices should EPA impose? And also, will the recently issued White House executive order entitled Restoring Gold Science Standard have any impact on the new chemical review process? We were going to have Rich start this one.
Yeah, so CBI overclaiming has been a problem. It certainly was a problem prior to Lautenberg. I'm sure anyone who worked on new chemicals prior to Lautenberg, and you'd see a PMN or an LVE where every CBI box was checked, and you could go on the internet and find a lot of that information publicly available. It's very frustrating from an EPA staff standpoint, and that was a problem. And the statute clearly places obligations on submitters now to substantiate many, not all, but many of their CBI claims, and makes impermissible claiming information CBI that's publicly available. So I think the statute has gone a long way to address the overclaiming. There is still some overclaiming, and we see it. I mean, we see it in other people's submissions. We counsel our clients to carefully consider what they need to claim and push back on a number of claims that they're making. And sometimes there's just, they're either not particularly experienced or their experience is pre-Lautenberg, and so they're just used to, especially the EH&S folks that are doing the PMN are responding to the business's mandate to say we have to claim everything as CBI. And what I tell my contact, the client contact, to say is, if the business needs that to be protected as CBI, make the business justify the substantiation. What would be the substantial commercial harm to the company's competitive position if that information was made public? And generally, we can either get an actual strong substantiation. This is what might happen. This is what the substantial commercial harm might be, and get a lot of the information, a lot of those CBI claims removed to provide to lessen EPA's burden, to more accurately represent what needs to be protected, and to provide more transparency. But in the end, there are lots of legitimate CBI information in a PMN. These are pre-commercial. They're things that companies have invested lots of money to develop, and now they're trying to deploy, and they don't have any revenue yet. Even if they have patent protection, and they don't always have patent protection because you can't patent everything. There's still an important business imperative for there to be some CBI protection. And so I thought Lautenberg did a good job of balancing those legitimate business needs for CBI and the need for transparency. And EPA's review of CBI claims and continual denial of CBI claims. I mean, we frequently get approve some, deny some outcomes. Is Lautenberg working as intended? And part of it is submitters, as they get more experience, will be better at not overclaiming.
Kyla, would you like to weigh in on this one?
Yeah, I think we've covered the CBI. I think it's important to address the executive order, the Restoring Gold Science Standard executive order. My opinion is that if new chemicals were to adopt those standards, the entire program would stop in its tracks, because everything that new chemicals does is so-called secret science, right? It's non-peer reviewed, a lot of industry science, which is kept from the public. There's a lot of CBI, sometimes even epi studies on analogs. And it's not necessarily reproducible, because reproducibility is not something that can be established in one study. It builds up over time. And we're talking about new chemicals. So it's kind of like an oxymoron to say, well, did someone else reproduce this? So also, achieving all 9 of those criteria that's in that executive order in any one study is extremely rare and probably non-existent on a new chemical. So I think that this executive order opens the door for political appointees to reject good science for all the wrong reasons, and it would really harm the accuracy and good decision-making that new chemicals is capable of.
Larry, you got an opinion on this one?
Not really. I mean, that hasn't already been stated. I think the CBI issue is bedeviling for all the reasons that Rich and Kyla both expressed. And so I appreciate the impacts that it has and some of the motivations, but I wish I had a genius idea to solve the problem. And that's, what I'd like to bring to the table, but I frankly don't have the light bulb going off over my head presently, but maybe you do, Greg. What's your thought? You've seen probably as many PMNs as I have from the inside as well as the outside.
It's a very complicated issue. Otherwise, we would have solved it decades ago. Okay, but it's the program still exists. It still works. I think we sort of may have made people feel a little negative about it today with this panel discussion. Maybe Nancy Beck will make us feel better in the next talk about the new chemicals program. But hey, this program still is there, and I think it still will stay there as long as they get enough resources to keep it running.
I think that's for all stakeholders to ensure.
Yeah, I see Madison is sitting up there getting ready to cut us off. So just want to say thank you all very much. This was a pleasure doing this with you all today. And maybe we'll get a chance to do it again.
Thanks for including me.
Thank you.
We hope you enjoyed this rebroadcast of the TSCA New Chemical session from TSCA Reform 9 years later. The topics discussed are as timely today as they were in June. All Things Chemical is produced by Jackson Bierfeld of Bierfeld Audio, LLC. We will be back again soon to further inform and entertain you about all things chemical. Bye-bye.